A Supreme Court ruling just dropped, and if you own a gun, this is one of those cases you cannot afford to ignore. Because the court just drew a line that could affect when police can enter a home and when they cannot use a safety excuse to take your firearms. Pause. Quick question before we continue. Are you subscribed? Because what I'm about to break down could help you understand the difference between a lawful emergency entry and a rights violation. Hit that button now because these updates move fast, and most people hear about them after the damage is already done. Here's what just happened. In a unanimous 9-0 ruling, the Supreme Court said police do not need probable cause, that means the usual crime-based standard, to enter a home when they are truly responding to an emergency and trying to save someone from serious harm. Now that sounds simple, but the impact is huge. Why? Because when guns, mental health calls, family arguments, and police welfare checks all mix together, your Fourth Amendment rights and your gun rights can collide in seconds. And if you don't understand where that line is, you can misunderstand what police can legally do at your door. So let me break this down for you in plain English. First, you need the story behind the new case. A man in Montana was in a crisis. According to the facts the court described, his former partner heard him make threats, heard sounds that seemed like a gun being cocked, and then heard what sounded like a gunshot, followed by silence. Police were called. When officers got there, they saw more warning. Signs outside and inside the home, including an empty holster and other signs that something was very wrong. They went in without a warrant because they believed someone inside might already be hurt or about to die. Now, this is where it gets interesting. The man later argued that police should have needed probable cause before entering. In other words, he said officers should have had to meet a higher legal standard before crossing that doorway. But the Supreme Court said no. All 9 justices agreed that in a real emergency aid situation, police do not need that higher criminal investigation standard. Instead, the question is whether officers had an objectively reasonable basis to believe someone inside was seriously injured or in immediate danger. That phrase matters a lot, so let me translate it. Objectively reasonable basis means the officers need real facts that would make a reasonable officer think help is needed right now, not a hunch, not a guess, not, well, maybe something bad could happen someday. It has to be based on what they actually know in that moment, and that changes search procedures in a big way. Most people think there are only 2 choices. Either police always need a warrant, or police can do whatever they want if they say the word emergency. But the truth is right in the middle. The court did not give officers a blank check. At the same time, it also did not force officers to stand outside while someone may be bleeding out behind the door. Have you ever wondered why these cases matter so much to gun owners? Because firearms often become part of the story before anyone talks about a crime. A family member says someone is depressed. A neighbor reports screaming. An ex says there was a threat. Someone hears a click, a bang, or a warning about a gun in the house. Suddenly, police are not just responding to a crime scene, they are responding to what they say is a safety crisis. And once police are at that doorstep, the question becomes very simple and very serious. Can they come in right now, or do they have to wait for a warrant? According to this unanimous ruling, if the facts point to an immediate danger, they may be able to enter without waiting. That is the search procedure side of this story. But here's the crazy part. That is only half the picture. If you're finding this helpful, imagine what you'll learn in my next video about the exact words that can protect you when officers start asking questions about your gun at your home or during a stop. Subscribe so you don't miss it, because knowing the law after the fact does not help nearly as much as knowing it before the knock comes. Now, let me explain the other half, because this is the part nobody's talking about enough. This new ruling does not erase an older unanimous Supreme Court case that helped gun owners in a major way. That earlier case is Caniglia versus Strom, and if you don't know that name, you need to. Here's what happened there. A man had an argument with his wife. During that argument, he put a handgun on the table and made a disturbing statement. Later, police got involved for a wellness check. The man agreed to go to the hospital for a psychiatric evaluation, but he said he did not want his guns taken. After he left, officers went into the home and seized his firearms anyway. The lower court said that was okay under something called the community caretaking doctrine. That sounds fancy, but the idea was simple. Police sometimes do jobs that are not about investigating crimes. They help stranded drivers, manage accidents, check on people, and deal with public safety issues. So the lower court basically said police were just doing caretaking work, so the entry was fine. The Supreme Court said absolutely not. All 9 justices agreed that this community caretaking idea does not give police a free pass to enter a home without a warrant. The court said homes are different, cars are different, roads are different. What police can do with an impounded car does not automatically carry over into your house. And that matters a lot for firearm rights, because the Caniglia case involved the seizure of guns from inside a home. So when you put these 2 unanimous cases together, a very clear rule starts to appear. Rule number 1, police cannot use some vague, open-ended, We were just trying to help excuse to enter your home and take firearms. That is what Caniglia shut down. Rule number 2, if officers have real, immediate facts showing someone inside, maybe badly hurt or about to be hurt, they may be able to enter under the emergency aid exception even without a warrant. That is what the newer ruling confirmed. And this is the part that shocked me when I first dug into it. Both of these things can be true at the same time. Your rights are still strong inside your home, but those rights are not absolute when a genuine emergency is unfolding. Here's a hypothetical example to explain this. Imagine your brother sends texts saying goodbye, says he has a gun, and then stops answering his phone. Police arrive. Through a window, they see an empty gun case and blood on the floor. In that kind of situation, officers probably do not need to stand there waiting on paperwork while minutes pass. The court is saying the Constitution does not require that kind of delay in a real crisis. Now change the facts. Imagine a neighbor says, I think he's acting strange and I know he owns guns. Police show up. Nobody hears threats. Nobody hears a shot. Nobody sees signs of injury. You calmly speak through the door and say you do not consent to a search. In that situation, the government has a much harder time claiming an emergency entry is legal. That is where Caniglia becomes powerful. Now, quick legal note. This is educational information, not legal advice. Always consult an attorney for your specific situation. Here's what most people get wrong. They hear about one case and think it settles everything. It does not. The law often turns on facts, tiny facts. What was said on the 911 call, what sounds were heard, what officers saw before they entered, whether there was silence after a threat, whether there were signs of injury, whether the danger seemed current, not old, not possible, not theoretical, but current. And that word current is a big deal. The court was not talking about general future risk. It was talking about immediate danger. That is why this ruling could change how courts look at firearm-related welfare checks, domestic response calls, and possible suicide interventions. The question will often be, did officers have real-time facts showing a serious emergency, or did they stretch a vague concern into a warrantless search? Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the gun owners and rights-minded viewers who get these updates first. Click subscribe, because this area of law is changing through real cases, not headlines, and I want you ahead of it, not behind it. Let me take this one step further, because this is where it gets personal for you. Imagine you are at home. You legally own firearms. Maybe you carry. Maybe you keep a bedside handgun. Maybe you have hunting rifles in a safe. You are not committing a crime, but someone calls in a welfare concern after an argument, a scary text, or a bad misunderstanding. What happens next may depend less on your gun ownership itself and more on whether police can point to facts showing an urgent need to protect life. Most people think the Second Amendment question comes first. A lot of times, it does not. The Fourth Amendment question comes first. Can police get in? If they lawfully get in under an emergency aid theory, then everything they see in plain view can suddenly matter. Firearms, ammunition, drug evidence, notes, damage, injuries, all of it. That is why search procedures matter to firearm rights. If the entry is unlawful, the seizure may be challenged. If the entry is lawful, you may be fighting a much harder battle. But wait, there's something even more important. A lot of viewers hear this and ask, okay, so what should I do if officers show up? First, do not physically resist. That can turn a legal issue into a deadly issue in seconds. Second, understand that consent still matters. If officers ask to come in, your answer can matter. Third, if officers say they are entering because of an emergency, the courtroom fight usually happens later, not on the porch. That is hard to hear, but it is true. And don't make this mistake. Do not assume that being legally armed automatically protects you from bad outcomes during a welfare check. The law may allow the firearm. The situation may still be dangerous. If officers believe there is an immediate threat, they may act fast, very fast. Now, that does not mean police win every time, not even close. Courts still have to test the facts. Was there really enough evidence of an emergency? Did the officers limit their actions to dealing with the emergency? Or did they use the emergency as a shortcut into a home they otherwise could not search? That is where future cases will be fought. This is why I think this ruling could change more than people realize. It will shape training. It will shape police reports. It will shape how officers explain their reasons for entering a home. It will shape how defense lawyers challenge those entries. And it will shape how gun owners think about wellness calls involving firearms in the house. Most people think the big legal danger comes from a new gun ban. Sometimes it does. But sometimes the bigger danger comes from procedure, from how the government gets into the home in the first place. Because once that door opens legally, the whole case can change. And if you care about your rights, here's the bigger lesson. You need to know both cases together. If you only know the new emergency aid ruling, you may think police can always come in. Wrong. If you only know Caniglia, you may think police can never come in without a warrant. Also wrong. The real rule is tighter than the government wants and narrower than many gun owners fear. Police do not get a general caretaking pass to enter homes and take guns, but when specific facts show a real emergency, the Constitution may allow immediate entry to save a life. Laws and court rulings move fast, and one misunderstood case can give you a totally false sense of security. Subscribe right now because in the next video I'm going to show you the exact difference between refusing consent, staying silent, and making statements that can be used against you after police find a firearm during a so-called welfare check. So here's the bottom line. The Supreme Court has now made two things very clear. First, your home is still your strongest zone of privacy, and police cannot rely on a fuzzy community caretaking excuse to go inside and seize guns. Second, when officers have real, immediate facts showing someone may be seriously hurt or in danger, they may be able to enter without a warrant under the emergency aid rule. That means your rights still matter, but so do the facts in the moment. And in cases involving firearms, those facts can move faster than most people think. Pause. If this breakdown helped you, subscribe now and stay with this channel because I spend the time reading these cases so you don't have to learn about them the hard way. And one last simple reminder, this video is for education only, not personal legal advice. If something like this happens in your life, talk to a qualified attorney in your state as fast as you can.